please, your my lord, this item may be listed on 19, my lord, along with item number 25. Uh, Here, my lord, that's 85. There, my lord,
19 is there for tomorrow. What is the matter about?
my lord, same matter with item 25. Here, my lord, we only challenge the minutes of the uh, market settlement. I have taken the content from the other side.
Oh, 25, wait, 25.
On last occasion, they produced the minute, and we have to challenge the minute.
Let us
That's why-
challenge it. What is it?
Yes, sir. We have challenged by this read period. We have
You have not submitted the document. You have not submitted land valuation certificate, land holding, income tax, GST clearance. What
while
is
at
that?
the other side also not submitted several
No, no,
four
that,
to
that
five
is a different.
documents.
That is a different.
Malad, both the matters.
We'll take it up today.
Fine.
We'll take it up today. You list that today also.
Fine.
Yes.
No, no. Yesterday we filed.
Well, it's come up today.
Fine.
I filed urgent matter only yesterday, my lord. Take it up after 2
What is it?
urgency, my lord, against the challenging the my lord. We have I along with the rest of the world technically, my lord, for settlement of
Tomorrow. Not there. Tomorrow. All motions tomorrow, new one.
By vaccination, item number 34, your lord, for withdrawal.
34, okay.
But if I have these instructions on the record, your lordship, these are the instructions received from my client.
They are bit was disqualified. Okay, right. Mr.
It is okay.
KJ Saikya, and counsel for the petitioner. Submits that he has received instructions from the petitioner by letter dated 16/12/2024. Asking him to withdraw the writ petition on the assurance of the authority for revaluation of the technical bid of the petition. That's all. The petitioner counsel thus prays that he may be allowed to withdraw the writ petition with liberty to refile, file same effect. With the needed act. Mr. Bigo Boy appears for the PW on the prayer of Mr. KJ Saikya that his petition is dismissed as withdrawn with liberty of speech.
Other item number.
Huh?
Item number 19.
Item 19, what about it?
Yes, Lordship, I am appearing on behalf of Mr. A.K. Gupta, your lordship. Lordship, we have some medical urgency today, your lordship. I pray that the matter may be passed over for this. Consent has already been taken.
Item 19,
19 also.
electricity connection.
Yes, your lordship.
So it has to be provided, that's all. What is it? No, but you see, there is a property dispute, correct? There is a property dispute. Now, whoever is deciding in the premises, if he or he wants the electricity connection, the only thing that if it is here, is whether the person who has asked for the connection is actually residing there. That's all. What else is to be decided?
Lordship, I am not in this matter, your lordship. Lordship, I take it tomorrow.
Where is he?
Lordship, his son is having certain difficulty, your lordship. Certain vomiting, certain medical urgency.
Okay, right. Who is he, Mr.?
A.K. Gupta.
For no, take it. So how does it matter? We can dispose it of without him. Okay, right. Not tomorrow, next year. On the prayer for adjournment made on behalf of Mr. Akhil Gupta, let's ask for the petition. This is the matter of the petition.
Appeals, Your Lordship. I beg to mention item number 27.
Yes,
Matter of become
Mr.
MS Mondal of behalf of DFM.
Mr. M.S. Mondal,
Yes, Lord.
appearing on behalf of Mr. D.A. Kayub. Let's ask for the petition. Submit the rate petition has become instructed. Accordingly, the rate petition is dismissed as instructed. After we take it. Why so?
May I please, Your Lordship? Lordship, I beg to mention item number 28.
Yes.
But with the consent of the other side, Lordship, Lordship, there are similar two other matters which has already been listed in a different bench, and already both sides or arguments already concluded.
So we'll await that
Lordship,
decision.
kindly tag this matter along with
How can we tag it if this has already been heard?
already.
Do you understand?
Similar matters, Lordship.
Do you, Mr. Counsel, do you understand the meaning of heard and reserved? If it's heard and reserved, this cannot be tagged with that anymore. You have to await. What are the cases that that have been heard?
This is the same company, Lordship. Atmamurthy Limited.
Mr. Counsel, what is the number of the case?
Yes. 2797 of 2014,
2797 of
2014,
14 and
and 2845 of 2007.
2845 of 2017,
7.
right? What is your name?
SJ Twin.
Huh?
SJ Twin.
Your name is not here. You have SJ
SJ Twin.
as like yeah, appearing on behalf of
Senior conductor.
appearing on behalf of Dr. Ashok Saraf, let also for the petition of submit that WPC 2797 of 2014 and 2845 of 2017, which are similar matters, have already been heard and judgment reserved,
And not yet.
not reserved.
Not yet.
Judgment heard. No, it's not, judgment's not been heard also.
Third plot.
Which court?
Not yet reserved.
Just give me the last order of 2797 of 2014. Submit that, just say that, submit that similar matters that is WPC are heard matters. Before which court?
Justice Manik sir.
Heard matters before the court of the Honorable Mr. Justice Manish sir. Accordingly, place that the present matter may be discussed along with the above two matters. This is state along with the above. Before the that
Highly offensive.
listed around the house. Yes. Okay, right. Miss, what is your name? Huh? MM Kotaki, Learning Council for the Age and Vetting Department is granted 3 weeks time to file affidavit in opposition. This is the matter of the case.
Item number 11. Can I pass over for the case? My lord, the authority has directed us to speak today, my lord.
Huh?
The authority has directed the petitioner, my lord, to have a meeting, my lord, today itself. That,
These matters should come to court. Rate. Who are we to know what is to be the rate of a market?
that's according to the principal act, my lord, there's a rule out there.
So when do you want? After the
After that.
vacation?
After that.
Okay, right. Mr. NJ Dutta, learned also for the petition submit that the authorities have called the petitioner to have a discussion with regard to the grievance of the petitioner, that is enhancement of the market rate.
Yes.
He prays that the matter may be listed after the vacation. So accordingly, list this matter after.
I'm okay.
Twenty-two. Huh? You're for the petitioner. Who is for the PWD? Correct. On the prayer for adjournment made by Miss. Huh? L. Sarkar, appearing on behalf of Mr. P. K. Das, the possible petitioner. This is the matter after the vacation.
Hearing this number.
So your vehicle was repossessed.
Yes.
So what to do? You have not been repaying your loan.
Out of the 30.
So what is to be done? What we used to do this? What was the early how the earlier
The
cases
time of
disposed of?
recovery of the vehicle of no issue have followed by the.
What procedure should they follow? They should give you notice.
Yes, no notice has been
They
started.
should ask. Should they
No
give?
procedure has been
Mr.
followed
Council, did they give you notice to give the loan amount?
out.
Did they give you notice to give you to repay the loan amount or not?
Yes, I have received a notice not to repay the outstanding amount, Lordship. But Lordship, I have taken loan amounting to rupees 60,260, Lordship. And there the 30 installment has been going on. Out of the 30 installment, 19 installment I have already been paid.
What is to be done in these type of matters?
In this regard, Lordship, I have also filed an FIR before the officer in charge. And no FIR has been registered, Lordship. But in absence of me, Lordship, Lordship, only my mother, having is it about 75 years, Lordship, and the minor nephew has been present, Lordship. In presence of that, Lordship, 20 people are visited, Lordship, in my residence, Lord, and give sitting to her, Lord.
I don't know.
So that is a mandatory.
I don't know about that. What to do? What is to be done?
But my prayer is not only that, Lord. My prayer is that to recovery of the vehicle, Lord.
You
Which was not followed by the insurance authority, Lord.
you pay the loan. You pay the loan. You cannot take things for free.
No,
This is-
I am agree about that, Lordship. I have a duty bound to repay the outstanding amount to the bank authority, Lordship. As per the agreement itself says that. But, Lordship, there is a rule is governed by the law in the constitutional country, Lordship. We have a constitution, Lordship.
Really? I didn't know.
Governed by the
Really, we have. We have.
Your Lordship,
Oh.
kindly be Paris, Lordship.
You know, Mr. Councillor, please do not shout. Please do not shout. This is not a fish market. Okay. I do not know what you're trying to gain by shouting.
Kindly be Paris, Lordship. Reserve Bank is circular, Lordship. There is a category.
Anyway, we'll take it up tomorrow. This is the matter. You think about it. This is the matter tomorrow.
Sure.
Regarding my non-payment of my rent bill, and my claim has been fixed. That is page 58.
If your claim page 50, 58,
Is collected from online,
page 58.
collected 6.
So if your claim has been rejected, what is to be done?
Not a ground final you're talking,
Ah,
that illicit pay
contrary to the office order dated 1/7/27.
Ah,
How can
So-
it be 1/7/27 of taken fine? Secondly, original TS abstract, not only the original. We have my God set out the DZC test party device technical section. And we have already set up. Now they are
this
saying,
must be a typographical error anyway.
maybe, my God. Actually, I
We'll
have-
list it after vacation.
Another instruction may be set for the why my claim has been rejected because
That's all. We do that.
instruction may be wrong.
Okay, right. Third, Mr. and Hawk Leonard Council for the petition. To submit that the petition that the petitioner's bill has been rejected by the PhD. Without giving proper reason. Mr. Aragoy. Appearing for the PhD department submits the due obtained instructions. This is the matter after the vacation.
I checked, see my God, address same by the candidate in order page 56. Here ground is different. Same thing ground is
Page
page 56.
56. Yes,
As instructed, user is asked to drop the DT set and resubmit. That's been
page 56.
Fine.
Doesn't say as instructed. Where? Page 56 is this.
50.
Huh?
56, 6737.
6733. 6733 is item 3. Please use the cause list. Don't go by your whatever you have got.
Basically, sorry, page 6.
Yes.
Here it is that as instructed, division is asked to drop the DT set and resubmit. Already I have installed DT set. Now they are saying that you drop that and resubmit it. There is another account.
Yes. All, huh?
Up to 7 mile or set. Okay.
National report or the context of PW department.
Where is your work order?
What happened? The respondent, they have at least they have not provided any document. I have got my amount.
So they have not provided any documents to you.
This may be issued to them.
Mr. Counsel, I'm not issuing notices like that. You show me some document. Where is the work order issued to you on the basis of which you have supposedly done some work? Where's the work order?
I will put it that
Huh?
order along with affidavit. I didn't exit it. Vote for motion. I will take report is honorable court. After I try to collect the city.
What work did you do? What work did you do? What contract work did you do?
You know, what when the T&D Department of October, they have decided to construct a residential school for Bar Raza Patho Ashram situated at Tamulpur district of Baksa district. What happened, Your Honor? Accordingly, the government of Assam, near about 7 crore was already released. And during that period, the previous contractor who did busy in his work, the then deputy commissioner, he was the chairman of the construction committee. They have decided to appoint me. And orally they have appointed me and I have done by incurring more about.
Orally they have
Okay.
appointed you. Who has appointed you orally?
They have decided in the committee. Owner.
Who? Which committee?
The committee was the Baraza Patwa from Residential School project implementation. And accordingly, Your Honor,
What, which school?
Baraza Patwa from Residential Project School Project Implementation Committee. They have constituted a committee, Your Honor, to conduct the
So where is the committee minute?
what happened, Your Honor, they have not yet provided any document.
When was this? When did they appoint you? Which year?
In the year of 2014, Your Honor, I have
2014.
14,
And what work did you
20,
do?
20 June of 2014, Your Honor, I have mentioned
And you constructed a school.
yes,
For what is the value?
what happened,
What happened? Not what happened. What is the value?
Chief, the Government of Assam, they have Government of Assam, about near about 12 crores rupees for rupees 12 crores.
Is it 12 crore?
12.
No work order, nothing. No, sorry. I'm dismissing your writ petition. There's nothing. I've looked.
No, I'll produce the copy.
You,
Yes,
what do you
making
produce?
money.
You
I-
said,
I
you
am
just
never
said, you have said that you have been appointed verbally. What, if you have appointed verbally, what verbal document can you produce?
My financial position is totally different, you know, kindly. His condition may be, kindly.
Mr. Council, a 12 crore project, no one is going to give it to you verbally. You, if you want, you can withdraw this and bring documents to show that you have been selected through a process, through a tender process, that you have been given a work order, that you have been given a completion certificate. Then I can understand. There is nothing here. One cash memo for 3,63,000 from one Kishore Deka, supplier of bricks. That's all. What is it? It's Kishore Deka, who is he?
Purchase.
He has purchased.
Subject before a deputy committee.
The only things that I have got here in the petition from the government is your registration number has been renewed. That's all.
Can you
And that also from,
17?
huh?
Can you come to page 17? Yes. That photo is the picture. Right, the picture. Monitor picture, yes, Maharashtra.
Where is your representation to the authority? Any representation to the authority? Any representation in your writ
Yes,
petition?
yes.
Where?
Next, from page from 45 to Your Honor, 45 to Your Honor, up to 62. Various representation I have made.
To the
before.
Honorable ADC, Tamalpur come chairman. Cool.
Yes.
What is ADC? What is ADC? ADC means
Additional deputy committee.
Additional Deputy.
Yes.
Tamalpur come chairman.
You are the chairman.
Application for release.
Again, Your Honor, on 31/7, 2000.
I am a first class contractor, the project committee so and so. Engage me as a contractor orally.
Then
As per,
when I have filed representation before the Honorable CMO.
you see, Mr. Council, you see, you go to the civil court. This is not we cannot go, there's nothing out here, no document.
Kindly come to page that, 48.
48.
Is a representation before.
Mm.
Honorable
If it's between you and the school,
Yes.
you go to, this is a private dispute, you go there.
When-
Page 48 there.
The representation before the Honorable
Chief Minister,
for release of the outstanding. And accordingly, the office of the CMO, at page 52, they have issued a letter to the concerned.
okay, right. I'm dismissing your repetition. Yes, anything to say? Nothing here. Huh? Nothing is there, not. And for a 12 crore project, you spent only 40 lakh. You finished the project, you finished the building. Resolution passed by the school. He says he doesn't have it. Nothing is here.
I feel liberty to file it. Yes. Right, liberty to file it.
Mr.
Speaker.
B. Kakati learns also for the petition. Says that he may be allowed to withdraw the writ petition with liberty to file a fresh with supporting document. Good stuff. Mr. K. Gogoi appears for 1 and 2, while Mr. M. Chetty appears for 1. Good stuff. A perusal of the writ petition shows that there is no work order issued to the petition. In fact, the petitioner's claim for payment of contractual dues is that he had been verbally appointed as a contractor by the school management committee, due to which he incurred 40 rupees 49. However, there is no document in support of it. The prayer of the petitioner's counsel is allowed, writ petition is dismissed as withdrawn. So he is allowed to file the writ petition afresh if there are supporting documents to show that he had been appointed to construct the building. And there has been an admission of his dues by the respondent. Item number 9, yes.
In the Checker history, my lord, the 2014-15 I executed a contract work. After that contract was executed, closed, my lord, my LC money was seized, my lord. Thereafter, FCI made a further deduction for me of 21.66 lakhs. So that was another challenge before this honorable court.
Okay, it is that.
That matter. Whether the issue was, my lord, whether after issuing NBC and closing of the contract, still,
But now you have lost.
no, I have own also, my lord. Your lordship, judgment by division bench, just granted Supreme Court. Supreme Court also on merit has nothing said, my lord. Only said that this matter should be considered by the, maybe taken up to the GRC matter. Now the GRC was referred to a particular reference, my lord, lordship, kindly see.
Page?
GRC was page 102A. GRC petition of FCI matter.
Yes.
102A, lordship, 102, yes, my lord, paragraph 7. The point of reference was that whether after issuance of no demand certificate and refund of security deposit, FCI can initiate recovery against the downward revision of retail price during the contract. This is the point that this court decided in giving detail matter. Now this point went to GRC. A GRC, my lord, without giving any reason and all, my lord, lordship, can you see the finding? How, my lord, executive director can overrule the judgment of this court, which is just given a detailed reason. My lord, that your lordship will find page 120 of the impugn order.
Yes.
Last 5.21, last paragraph, my lord.
Yes.
Mere acceptance of NBC so submitted by the contractor and release of the security deposit thereafter to the contractor by the FCI does not either dilute the or obliterate the take-off clause of MTF
contract in any manner, in whatever manner. Moreover, the payment was so. Giving this much of logic, he eluded all these judgments.
Okay, right. Heard Mr. P. Chakrabarti, Senate counsel for the petition. To submit that the recovery of rupees 21.
Wait,
And he
total manner, total will be
Earlier, before the single bench, it was 21 or 26.
21 lakh 66,009.
Then how has it become 26 now?
Now,
Because of interest or something?
yes, madam. Interest, it has become
Adding
29 lakh
interest, my lord.
99,000.
My lord,
Yes.
in this case, I need to take instructions from the FCI, my lord.
No, you take instructions. I'm staying in.
Yes,
That's
yes,
all.
my lord.
Heard Mr. Sir, counsel for the petitioner who submits that the recovery of 21,66,907 from the petitioner's bill after a no demand certificate has been submitted by the petitioner to the FCI had been held to be bad in law by this court by judgment and order dated 6/12/2019 passed in WPC 3261 of 2016. The challenge made to the judgment passed in WPC 3261/2016 failed before the division bench of this court and the Supreme Court. However, the Supreme Court had held that the FCI could approach the dispute/grievance redressal mechanism with regard to the issue that has already been gone into. Pursuant to the decision of the Supreme Court in SLP C number 2032/2023, which had been disposed of by order dated 14/2/2023. The FCI issued a letter dated 5/6/2023 to the Grievance Redressal Committee giving the point for consideration to be decided as follows, inverted commas, whether after issuance of no demand certificate and refund of security deposit, comma, FCI can initiate recovery against downward revision of diesel price during the contract period. It is here, page 1028. I put it here, this red. Next paragraph. The Grievance Redressal Committee, while order dated 8/8/2024, decided the point of consideration in para 5.21, consisting of 3 lines, comma, which is as follows. Page 120, 5.21 it is. Issue notice returnable in 4 weeks. Miss, who accepts? Mr.
BK Singh,
BK Singh accepts notice on behalf of the FCI.
all the respondent.
All the respondents. This is the matter after 4 weeks to enable the FCI to file their affidavit. In the meantime, the impugned order dated 8/8/2024 passed by the
And also the demand notice, my lord,
demand notice separate
separately, Annex 25, my lord.
issued by the GRC and the demand notice dated
312.
3/12/2024 issued by the Assistant General Manager bracket CONT full stop bracket for General Manager Region shall remain state till final disposal of the case arithmetic.
Oblige, my lord.
Or is that till the next returnable date?
I leave.
Yes, yes, because
Yes,
let him get some chance first.
I leave. Well, this is a case where the petitioner is owns operates a coal depot from where coal is converted into coke and is transported to various destinations. Now, my lord, in the coal depot, my lord, a lot was been seized by the authority without following the procedure prescribed or without giving even any knowledge. I have all the credentials and the documents to show that I can establish the coal depot in that particular area. Normally, the pollution certificate is required. to
No, your coal has been seized. Why?
No reason, no reason, no reason.
Oh, another thing, your coal was seized in June.
Yes.
Why have you come now?
Not there.
Yes,
or-
Just 1 day before
Yes.
the incident.
Yeah.
Yeah, 1 day
And
before the
also,
occup-
we were lucky that we at least got the information that they are.
No, why have you come so late?
Well,
Huh?
well,
28.
this auction, we have given a reply. Your lot should kindly see the reply. First, your lot should see the notice at page 27. Page 27 is the.
Yes.
This is the notice. They had asked us to give the reply by 2nd of July. We gave the reply. That is, reply is at page 29. With all the credentials and the documents which are required and closed with in page 29. This was given on 2nd of July. Then 31 is the 69 is the invoices in regard to purchase of the coal. Then your lordship will find page 70. Page 7. 9 July 2024. This is the action taken report. Here also they are not very clear. We are in our coal is in this particular lot, one of this particular lot at serial number 5 at page 71. Not against all the lots. It's only against the lot number 5.
Lot number 5 is Bitul Saikia.
Yes.
And this person is forward.
Notice was served on the landowner. I am the owner of the depot. I took that land from him to store the coal. Lease. And I have annexed the lease though.
No, just a minute. Okay, your forward is Levinsky. Yes. Correct.
He is
Yes,
the
sir.
owner of the land. And we have taken that land on lease from Bitul Sector that your lordship will find at page 70. Let me conclude that my learned friend will. Annexure 1.
This is Bitul Saikia. This letter is to Bitul Saikia.
Yes. Sir. Annexure 1 is.
Coal storage as a service.
They have not made any inquiry. I have given the document to show page 17 is my lease agreement with Bitul Sector. And in the reply, I have categorically stated that this is taken on lease from the good sector. Your Lordship will kindly see
What is this page 31?
page 31, my lord, is these are the invoices in regard to purchase of the coal. I have to
Purchased by whom?
by East India Trading Company.
And East India Trading is
I'm the sole proprietor.
you are the proprietor.
And even Bitul Chakia has given the explanation at page 29, your lord. Page 29 explanation of Bitul Chakia mechanic.
Yes, then
Then, my lord, they have given the action taken report that which I have referred just now is at page 70. The sub-division officer civil has entrusted this to the director of geology at page 70, and 71 is the lot number 5 we are concerned.
Bitul Saikia not allotted. What do you mean? Not allotted. The land is not his. Or what? Okay.
Bitul Chakia has never claimed that it is his coal mine. My lord, with utmost respect, I'll separate that only if you store more, if you deal with more than 500 metric tons of coal in a particular year, only then you will require dealership registration. Otherwise, it is not required. And we, in spite of that, we have a dealership registration for this. It's not that we'll operate a coal and will invest our money without taking the statutory permissions. And you'll also see now they don't do anything. Then suddenly, my lord, they decide to auction it. Auction notice is at page 73. Oh, it is cost to the state. Malad, if the auction is state till the reopening of the vacation or immediately after reopening, let my learned friend have proposed instruction. Malad. But if this is done, my lord, I'll suffer irreparable loss and I'll be paid.
They have got another case also like this.
Yes, madam, that's a different. There I have got the statutory license.
Out here you don't have the license.
So here also we have. The identity.
Where is the license?
But your loss will see. There. Your loss will see in item number 10.
No, I'm talking here in this case. Huh?
No, it's not required, madam. I require
Is it for storing is the license required?
under which provision, madam?
I don't know. You tell me, is permission required for storing? I don't know.
My lord, your loss will see page number 25 of this case. This is under the mines and minerals. And if your lordship do and there is an Assam Mines and Minerals Dealers Regulation Rules. Here, if it is
No, so what is wrong? He's storing coal in some Bipul Kalita's land. How does it matter? Yes, lot number 5, you don't auction it for the time being.
lot number 5 means they have also given it very tactfully. Your lordship will see the page number, the auction notice at page 74.
No, 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 I'm not, no, 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 only mine, your loss will see page. No, in the auction, sorry, your loss will see. No, 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 now your loss will see how auction notice at page 74. Let me submit, and I'll try to assist your lot. Page 74, your lot will find lot number 5. Ipongani Notungao.
Yes, same thing.
Then lot number 6 also they say Ipongani Notungao near firing ring. Then lot number 11 also they say Ipongani Notungao near firing ring. And problem is that today I don't know which lot they have marked this as 5 and 6.
Which lot there marked as?
5 and 6. Oh, all this is up to Ipongani government. Or your lordship may make it clear in your lordship's order that so far the lot considering the of the petitioner.
No, we will mention,
Yes.
mention the Caesar memo, that page 28.
Yes.
'75, there's no serial number 5.
No.
Yes, 71 serial number 5. That's enough.
Yes.
Because out here before I guess same is there.
Category specifically mentioned.
Yeah.
Yeah.
But I heard Mr. D.D. Pawar, senior counsel for the petitioner, assisted by A. Chakrabarti. Oh. A. Chakrabarti, who submits that the petitioner is the sole proprietor of MS East India Trading, comma, which operates a coal depot in Tinsukia, Assam. The petitioner had bought coal from from one Longyang Phom, Longyanphom, comma, Longlang, Nagaland, and stored the same in the land leased out from one Bitul Saikya, which is no, and in 2 bigha land, no?
Yes, sir.
2 bigha,
Annexure 7.
2 bigha piece of land. No, this is 1 bigha. How can it be 2 bigha? How much was the land that you have rented out?
At least it is there, madam. Yes, sir. 2 bigha, 2 bigha. Lease land was 2 bigha as per the lease date, as per. the
Okay. To
Annexure 7.
as per which has been whatever it is. 2 bigha land, 2 bigha piece of land that has been leased from one Bitul Saikya under dark number 47, bracket, on dark number 47, correct?
Yes.
At
Covered by periodic partner number. 20.
covered by PP number? Huh? Covered by which dark?
127.
At a dark number 127,
Page 29.
page 59. Covered by dark number 127. No, but then you see page 29 talks of dark number 127 and the land measures 7 bighas, 2 kathas and
That is
10
the
acres.
entire land.
Yes.
Page number 71 also talks about dark number 127 now.
No, talks of dark number 47.
Or it is government, madam, dark number 47 gone, but in the notice of the assessment at page 71, it says 7 bigha 2 kathas under dark number 127, PP number 21. In the subdivisional officers.
Okay, okay. No, out here it is dark number 127. Okay,
One.
okay. Okay. Otherwise, 127, 127 PP number 21, located at Tipong Natun Gaon. TIPONG, Tipong, Pani, Tipong Natun Gaon. Pusta, next para. But out here it says Tipong Pani Natun Gaon. Okay, next. Pusta. The petitioner's counsel submit that the petitioner's coal was suddenly seized by the subdivisional magistrate Margarita by notice dated. Is it?
Yes.
28/6/2024. Pusta. He submits that the petitioner clarified the source of the coal and his ownership of the same. However, the respondent number 3 submitted an action taken report dated 9/7/2024, listing the petitioner's coal depot among the seized assets. Pusta. Adding to the petitioner's grievance, an e-auction notice
73.
has been issued for 18/12/2024 by the respondent number 6, which includes the petitioner's coal stock. Pusta. Issue notice returnable in 3 weeks. Returnable in 4 weeks. Mr. K. Gogoi accept notice on behalf of 2, 3, 4, and 5. Mr. S. Data appears for point number 1. What about 6? MSTC Limited. Petitioner to take steps for service of notice upon the respondent number 6 by registered post with AD within 3 days. Then you're right. In the interim, the respondent authority shall not act upon the e-auction notice with regard to the coal that has been seized by notice dated 28/6/2024, bracket Annexure 6, and lot and serial number 5 of the action taken report dated 9/7/2024, issued by the subdivisional officer, bracket civil, Margarita. That's all. Bracket beside bracket page 71. Here's the next returnable date. This is the matter. This is the matter on 30. When?
And this is the other lot, let's say, it also says only the lot number will be 4.
But the dark number and all will be changed also.
That is only one page, your lot, so see page 57. But we have that. 57, your lot will see first, 57. 57.
34 years.
57 is the lot number 4.
No, what does it say?
Oh, yes,
34?
37.
Yes. No, what have you given me? Okay, no.
34. 39.
What is the reason?
Based
Oh, yes, you say that you are allowed how much?
no. We have purchased from Coal India only 269.46, not 600 as per.
So you mean to say the seized amount is
Yes.
269 only?
Yes. That lot number, that's why we are lot number 4, my lord. Yeah, please.
Okay, whatever excess they find, then
Yes.
let them take it.
No, but you
Huh?
will see the lot number 4,
Okay.
57. At lot number 4, they have said 702 metric ton. 702 metric ton is lot.
702 metric
And
ton.
I'm claiming only 269.46.
Okay, let them take
270.
away the rest then.
Yes, 270. Yes, ma'am.
Yes.
Oh.
And where you are saying that you are 270, where is that?
Well, we have given the receipts and we have compiled it in the chart, the entire quantity of those.
No, I want to know from you.
Yes, ma'am. You'll also find the invoices, page 37 to 55.
Okay, right. Heard Mr. BD Power. Did by The petitioner's case is that he is the sole proprietor of MK Coal Supply located at Borgolai number 1, Tinsukia district. Assam. On 15/7/2024, the respondent number 3 seized coal stored at the petitioner's premises without prior notice. A notice was issued to the petitioner alleging that approximately 600 Huh?
It is not mentioned. Page 35, what is it?
Just let me see.
Page 35 is the original copy. They have overwritten and after that 600.
Huh?
Page 35,
No.
that they have.
It's not overwritten, it's cashed out and correct.
Yeah,
Done it.
600.
600 what?
No, not mentioned. But in the notice at e-auction notice at page 57, they have said 702 metric ton.
Whatever it is. 600. No, but that 600, 600 approximate that coal was stored within his premises without clarifying whether the 600 was metric tons or not.
Not cubic meter.
The petitioner replied to the said notice dated 15/7/2024 by letter dated 18/7/2024. Stating that he had been running the coal depot on lease by taking the same on lease from the Patatar Sri Ron Bahadur Tamang. Next paragraph. The petitioner's counsel submits that in terms of the sales orders that have been annexed to the writ petition from as annexure 8 series, from page 37 to 55. The petitioner is storing 269.46 tons.
70.
You have given the exact amount. 269.46 tons of coal. As on date. As on date.
Yes.
This invoice date is of 2022.
My lord, this coal was purchased from coal auction by Coal India. That is a
This is of 2022. You have kept coal for so long.
first we have to store it for a that for that. Well,
Hmm.
270 your lot will beat it approximately.
Okay, anyway, that's all right. Huh? Anyway.
At 270
Okay, no, since you have given me this list,
Yes,
I'll give you this.
approximately. It's
Point
all-
46, huh? What have I said? Which is approximately 270 tons of huh? This time. The petitioner is aggrieved by the e-auction notice issued by the respondent number 6 on
it is scheduled tomorrow.
issued when e-auction notice.
Just no date is there.
Okay, e-auction notice by which auction of the petitioner's coal stock is scheduled to take place on 18th of 2020. Yes, what have you got to say?
Lot number
270 tons. Where?
57.
Mr. K. Gogoi, the learned counsel for the respondent number 1 and 2, submits that in terms of the e-auction notice, as per the e-auction notice pertaining to lot number 4, which is the petitioner's lot, comma, the coal that is to be auctioned is 702 metric tons. So he submits that even if a stay order is to be issued, comma, the stay order may relate to only 270 tons.
But in that area, but there are other coal also of other coal. We are not talking about them. We are only concerned with 270.
Anyway, but then metric tons and tons is different. Huh?
Yes.
Metric tons is huge.
And in they have not, will not be capable to measure it.
Okay, next, right. Mr. B.D. Pawar, learned counsel for the petitioner submits that only his coal amounting to 270 tons approximately may not be touched during the e-auction process. And he has got nothing to pay with regard to the remainder of the coal that has been mentioned in lot number 4. Next, issue notice, returnable is for which Mr. K. Roy accept notice from the respondent number 1 and 2. Huh? Okay, 2 to 5. Mr. S. Data, for respondent number 1. Petitioner will take steps for service of notice upon the respondent number 2. 3. 6. For instance, proceed ready within period. In the interim, the respondents are directed not to auction 270 tons of coal, approximate 270 tons of coal, which is pertaining to lot number 4.0. out of the 702 metric ton that is to be auctioned. That's all.
It's not, but that's copy of it.
No, it's your job to do it. Your job. Do it here tomorrow. You got
No
enough.
auction मला that's why I made a request मला.
Huh? Same day. It's your job, Mr. Kazi. You come on the last day. You cannot have everything. Get enough time.
तो मला
Ah, yes, yes.
मला
It is by 1 o'clock. This order will be out. 2 o'clock it will be out.
we did not want to coordinate your lordship of looking into the order during the lunch hour. We are obliged.
My lord, calls. Petitioner has approached this court earlier also against actions of the municipal corporation. Now, before taking your lordship to the in action of the Home Department, just wanted to show one more thing. My lord, kindly come to page 101. This was the last section of the Guwahati Municipal Corporation, whereby they said that we are going to seal your premises, provided you don't give us a proper trade license and the NOC from the housing society of that particular complex. Page 101. Your lordship was pleased to grant the stay order in this matter, and it was decided on July 2024. Your lordship allows me.
Yes.
Yes, the NOC was also demanded matter from the society of the housing company. Now, your lordship was done a stay order and finally of 6th of July matter was finally decided. And there was an observation made in that particular judgment. I may take your lordship the relevant portion of the judgment at page 107.
Yes.
Para 13.
Yes.
This court has also perused the definition of the lodging house as defined in section 44 of the Act of 1971. It lists a house which visitors or other persons are lodged for hire for a night or more, and where there is a possibility of for sleeping everything. In the opinion of this court, the bed and breakfast facilities come within the ambit of serial number 12 of the Court read with section 3, subsection 44 of the Act of 71. Under such circumstances, it will be the mandate of section 180 of the Act of 1971 that the petitioners are required to obtain trade license for running the facility of the bed and breakfast facility. Now, I submitted that we don't have any problem with taking the proper trade license provided it is specified. And in para 15, your lordship will see, taking into account the above, this court is of the opinion that if the petitioners want to run the bed and breakfast facility, it would be a mandate of law that the petitioners obtain a trade license for homestay in respect of both the flats in question because bed and breakfast was not there. This court also duly takes note of the stipulations contained in the issue notice dated 21/2024, where it has been mentioned that the petitioner is required to obtain a no objection certificate from the residents of the ideal view apartment. Nothing could be shown by the learned standing on Guwahati Municipal Corporation as to under what power the said stipulation is required to be complied with by the petitioner. And finally, my lord, after I was directed to obtain a trade that so I was allowed to run, and on the very last para, page 109, says the authority did not insist on a no objection certificate from the society. Now, on 20th of August, the Commissioner of Police at page 124, I obtained the trade license. I have been running since. Now, on 20th of August, page 124, the Commissioner of Police, he passes an order. If I may read, this is under the Sarai Act 1860. He passes an order that the registration is required under the Sarai Act. Whereas it is expedient to regulate public sarais or buildings used for shelter and accommodation of travelers, the legal provisions for regulation of such public sarais are prescribed in the Sarai Act 1867. As such, the Act, sarai means any building used for the shelter and accommodation of travelers and includes in any case in which only part of the building is used as a sarai, the part to its use of such building. Now, he defines the section. Now, your lordship would kindly come to the very next page, page 125, where the IPS Commissioner of Police has been empowered by the government of Assam to do the following. Point number 1 and 2. The owners or keepers of sarais, which includes hotels, lodges, homestays, private hostels, or any building or part of a building used for the shelter and accommodation of travelers, are to register the sarais and also the names and residences of the keepers of the sarais with the office of the Commissioner of Police. I want to note, register the sarais and also the names and residences of the keepers. Now in para 2, he says that until such time it's registered, they are to remain closed. Now after such objection, the notice was served on me. I applied. I think shy away from such a day. I quickly applied. And before taking your lordship to the Sarai Act, the page 125, 135 is the form that I submitted. This is the inspection form. That's the inspection form. Point 9 is 135. Point 9. If the NOC for residential society obtained, if applicable. I'll take your lordship to the act. The act is silent. There is no provision asking for an NOC from such a society.
They're made up.
I say that I give the NOC from residents. I have annexed those 27 odd residents who have signed in my favor. From the builder, that is also annexed. My lord, from the landlord, it's a rented accommodation. And the sale deed also specifies. And I also provide a certified copy of the order of the chief. They choose the impugn notice at page 140. Everything else is satisfied, my lord. Even the fire safety NOC, everything, whatever certificate is required, I submit. Now, the page 140, the impugn notice, they say that the NOC from the residents of Ideal Hillview Apartment Welfare Society for further copy of application. I submit a representation thereafter, and they have been sitting silent ever since.
Yes, why not taking action? I want to know how many sarais have been registered with the police commissioner all over in this thing. All with all their numbers. Yes. Huh? And where is the requirement of having the neighbors or giving a no objection certificate? Yes. Yes. Hmm. Okay. So he can do anything. Can he do anything? You see, the source of power must exist for his exercise. Where is the source of power to ask for a no objection certificate?
Since we are on the act, my lord, we kindly come to section 13. Power of state government to make regulations. The state government may from time to time make regulations for the better attainment of the objects of this act, as provided that such rules be not inconsistent with this act or with any other law for the time being enforced, and may from time to time repeal, alter, and add to the same. All regulations made under this act and all repeals thereof and alterations and additions thereto shall be published in the official gazette. There is no official, there is no rule.
Yes, anyway, let him, you see, you come. Uh, huh? No, Mr. Counselor, I'm not on that. You see, he has submitted a representation now. So he has asked for approval of his application. Well, Mr. Counsel, you are the magistrate of the district. Then you take a decision, declare that. Yeah, he can write whatever he wants. What is the bar? Is there that application has to be written in the words that you like? He can do whatever he wants. You have the power to either say yes or no. Whatever it is, whatever it is. You see, Mr. Counsel, that's not the issue. The issue here is he has asked for he has asked for approval. Now either you give it or you don't give it. You don't give it. Take a decision. You cannot keep it pending. That's all. So that's all. Checklist whether it's followed or not. You do whatever. You can give 1,001 reasons. That's not a problem. But give some reasons. Either take a decision this way, that way. That's all. Correct, correct. But you cannot keep everything pending just like that. Right. Third, Mr. P. Bhardwaj, learned counsel for the petitioner will submit that the petitioner's application dated 22/11/2024 for giving approval to the Hillview Bed and Breakfast Facility under the Sarai Act, 1867, page 142, it is, has not been acted upon, has not been decided by the Commissioner of Police, bracket, INT, what is INT? Intelligence, right, Lord. What is, tilde. Mr. Srinath, learned counsel for all the respondents submit that he will obtain instructions with regard to the above, with regard to why the petitioner's application has not been uh, decided till. This is the matter of tomorrow, the after, tomorrow.
Friday, right?
Okay, 20, this is the matter of 20.
Lordship, the petitioner is before your lordship,
Item 20,
uh, 13 lordship.
12, yes, 13, yes,
The petitioner is before your lordship.
Yes.
Against the non-release of the performance security and security deposits by the petitioner while taking up a project work from the respondent of the user.
work has been completed.
The lordship, we find at page number 25. The completed project was handed over to the respondent on 17.
So you have not been given the security deposit and performance guarantee. Are you sure? Madam, this is he's completed the work. It's your duty to give it to him. There's no reason for you to keep it for one day. You have to give it back to him. You obtain instructions. Right. Mr.
Keep us.
B.
Pal.
Pal, appearing for the petitioner, submits that despite the petitioner having completed the contract and having handed over The building? What is it? And
Repair and renovation of existing room.
okay, and having handed over the repair, no, having handed over the building after repair and renovation in terms of the contract, comma, the petitioner has not been returned his security deposit and performance guarantee. Miss A. Bora for the response number 2, 4, and 5. Are they the one who has to give 2, 4, and 5? What about 3? Miss 2, 4, and 5, and Miss A. Bora for response number 1, 3, and 6 shall obtain instructions as to why the security deposit and performance guarantee has not been released to the petition. List the matter. After the case, give the date in the secretary. No, before that. Yes. You see, you have to give back. There's nothing. You have to give back the money. Yes. Where is your additional affidavit, madam? Acha, this is the one. This is different.
That's fine.
No. No. There is a additional affidavit to be filed by you.
Man, me.
Yes, in the last order. That para 8 of that affidavit filed in the WPC.
Karate.
Para.
Go, man. Go check it out.
No, we will issue notice, but in the meantime, you please file that affidavit. Okay.
Check it out.
Whatever it is, madam, I've got to understand. I don't know now what is the thing. It is for me. It is not for you. It is for me. You know everything. I don't know what happened.
Okay, your lordship.
Ah, right. Heard Miss L. Saikhe. Learned counsel for the petitioner, who submits that the order dated 6/9/24, passed in WPC 6036 of 2026, has not been complied with. Issue notice returnable in 5 weeks. Petitioner will take steps for service of notice upon the respondent by a registered post with dated within 3 days. This is the matter after 5 weeks. In the meantime, the petitioner shall file an additional affidavit incorporating the affidavit filed by the respondents number 2, 3, and 5 in WPC 6036 of 2020. 2023. 6036 of 2023. Huh.
It's the matter that we had of the last occasion, we had taken the instruction that we are able to pay by way of a demand draft.
I don't know, it depends upon them. Okay. Then we have to discuss.
The only thing is, madam, with regard to the order of blacklisting, may I just point out 2 things? If your lordship will kindly come to page 51, the clause, blacklisting clause. We will just consider these 2 aspects, madam. After that, obviously, I'll leave it to you.
No, I think they'll have to file something.
Sorry.
We have to give them a chance to file something.
But what is happening is, last date of the tender is 20th. What we are paying by way of the IA may be allowed to participate subject to the outcome. If the blacklisting order is not satisfied,
I will obviously.
But
obviously go.
when there is a notice issued to you and everything is there, if it's all, then
It is-
well, the
I am not on the notice part. I am on just two aspects I'll point out. If your lordship will just come to the blacklisting clause, that page 51.
Yes.
Page 51, right at the bottom.
Yes.
That for these words, any fault made by the second party. The first party shall have the right to forfeit the security deposit and will have the right to blacklist the second party after notifying to rectify the mistake committed by the second party in writing for the act. Okay. Now, what I'm on is, firstly, there has to be a fault attributable to the person. And secondly, it has to be, a notice has to be given to rectify. Here is the situation, my lord. Obviously, the goods have been stolen. Now the person concerned is arrested. The rectification can only happen if it is recovered or otherwise. Now the question is, my lord, the lordship will kindly come to this judgment that Kunja. Here is the situation, my lord. The goods are stolen, which I didn't have any control over. Now, 2014, volume 14. 2014, volume 14 SCC 731. There are two paragraphs I'll play from this. One of the aspects that your lordships exercising power of judicial review, this lays down the parameter. Para 17 at page 740. Starts at 731. As my lord.
Para 17.
Para 7.
Yes.
That apart, the power to blacklist the contractor with whether the contract be for supply of material or equipment or for the execution of any other work whatsoever is in our opinion inherent in the party allotting the contract. There is no need for any such power being specifically conferred by statute or reserved by contractor. That is because blacklisting simply signifies a business decision by which the party affected by the breach decides not to enter into any contractual relationship with the party committing the breach. Between two private parties, the right to take any such decision is absolute and untrammeled by any constraints whatsoever. The freedom to contract or not to contract is unqualified in the case of private party. But any such decision is subject to judicial review when the same is taken by the state or any of its instrumentalities. This implies that any such decision will be open to scrutiny not only on the touchstone of principles of natural justice, but also on the doctrine of proportionality. A fair hearing to the party being blacklisted thus becomes an essential precondition for a proper exercise of the power and the valid order of blacklisting made pursuant thereto. Next sentence is very important. The order itself being reasonable, fair, and proportionate to the gravity of the offense is similarly examinable by a report. And then if your lordship comes to para 20, it is also well settled that even though the right of the writ petitioner is in the nature of a contractual right, the manner, the method, and the motive behind the decision of the authority, whether or not to enter into a contract, is subject to judicial review on the touchstone of fairness, relevance, natural justice, non-discrimination, equality, and proportion. Now, here is this case, whether something which is beyond my control, goods stolen, would it be a proportional penalty to the extent of where Supreme Court has in Gorkha held that it amounts to a civil death. But to that extent, your lordship will definitely examine the matter. And
But what about, can we pass an interim order that amounts to giving a
it will
final
not-
decision?
That is why, my lord, if your lordship kindly comes to the IA, I am not saying that your lordship will stay the blacklisting. I am simply saying participation subject to outcome. And your lordship will examine.
So everything will be delayed.
No, my lord. Your lordship will fix it immediately on reopening. And your lordship will examine the matter. If I am out, I am out. If these principles of law are not applicable, my reputation will be dismissed. And then I'll be out of the contract, the tender process also. So therefore, my lord, in fact, we have made that we have not asked for a specific order of stay. If your lordship kindly takes up the IA, that is what we are saying. That kindly allow us to participate subject to order. And that will be, my lord, a very fair Otherwise, well, what happened? At the cost of repetition, Gurkha has taken Eurasian equipment said that natural justice has to be followed. Notice has to be. Gurkha took it a step further and said that since it is an extreme measure, it will amount to a civil death of a party. So certain further things were added. And in Kulja, the fact that doctrine of proportionality is one of the tests while exercising power of judiciary has been held by. Whether it would be proportionate to what has happened. Yes, there might be
But, why you not why not allowing them to recover the thing from your bill?
what happens is, otherwise, that is why we are willing to give a demand draft. This is, if it is deducted from our bill, if GST gets factored, otherwise they will be compensated to the same extent. If we give them a demand draft, how will they be prejudiced? We are not saying, we are not shying away, we are taking responsibility so to the extent of our negligence. And in that kind of a situation, will it not be a fair order that I may be allowed to participate? Your lordship will look at it from the other perspective. Assuming my repetition is allowed, my chance will.
Sometimes you have to give chances to others.
And this is a matter of livelihood. And in any case, it is not that merely because I participate, I'll get it.
Let me hear. That is what for. Yes, then carry on. What? So he took 2 months or less than 2 months.
Page 54 is
FIR was dated. FIR was dated
25th of June.
25 June. And the consignment was lost.
Who concerned? Not April. Page 54. Your lordship, the dates are mentioned in that FIR.
Give me the date.
18th of May, one truck. 2nd of June, second truck is loaded. It does not reach the destination. And when after enquiries, we make the FIR on 25th of June. Not even a month. Your lordship will kindly consider this
The
aspect.
first truck was lost with.
First truck was loaded on 18th of May. And second truck was loaded on 2nd of June. And we lodged the FIR and simultaneously informed them on 25th of
So it is not 2 months. You have exaggerated a little bit.
But the mandate of the contract, that the assignment has to be.
24.
That's the contract.
One thing, as a balance of control is what I was on. If I assuming your lordship tests the repetition on the principles of doctrine of proportionality, and your lordship hold that it was not proportional because it was beyond my control. That is not within my control. In that case, eventually, even if the repetition is allowed, it cannot be status quo and it cannot be restored. So to that extent, my lord, the balance of convenience lies in favor of the. That is my submission.
Okay, right. Heard Mr. I. Chaudhary, present senior counsel for the applicant,
Repetition applicant.
writ petition applicant. Also heard Mr. K.P. Pathak, learned counsel for the respondent. The petitioner's case is that the petitioners were asked to deliver free textbooks for class 1 to class 12 students pursuant to an NIT dated 23/11/20. The however, two consignments were lost by the petitioner. The first consignment had been loaded on the truck on 18/5/24, while the second consignment, which had been lost, was loaded on the truck on 2/6/26. In terms of the requirement in the NIT, the free educational textbook were to be free educational textbook to be delivered in all the districts in Assam except for Barak Valley and Dima Hasao, were to be delivered within 24 hours of lifting from the Honda Central border. In case of the districts of Barak Valley and Dima Hasao, the educational textbooks were to be delivered within 36 hours of lifting from the Honda border. The two consignments mentioned above not having reached within the time period provided of the petitioner, the applicant was to have submitted an FIR and pursued the matter immediately. However, the petitioner submitted an FIR only on 25/6/2024. Next. Yes, sir, what is the effect of that? No, that blacklisted portion. Page. Page 51, clause 9, no? Next. Clause 9 of the agreement executed between the parties provided that for any fault made by the petitioner, comma, the Assam State Textbook Production and Publication Corporation Limited would have the right to forfeit the security deposit and the right to blacklist the petitioner, comma, after notifying the petitioner to rectify the mistake committed by it in writing, comma, before the action was taken. Clause 11 of the agreement further provided that the second party would remain responsible for any loss sustained by the first, would remain responsible for any loss sustained by the first party, bracket petition, while the books were in transit and till delivery at the destination is complete. Okay, this page 53 is part of the agreement. Next. That due to the loss of the free textbook by the petitioner's employees, by your employees, the books are lost by your employees, no, by the truck,
No,
by the.
I had engaged, I had a truck and the
You're a truck.
driver of the truck.
Yes, so they're employees, if the truck is yours,
Not
employees
my
have
truck.
to,
Not my truck.
anyway,
I had returned.
it's okay. As the free textbook has been lost, comma, the petitioner, the applicant was issued two impugned letters dated 8/11/2020, wherein it was stated that 26,416 books have been lost, which amounted to rupees 28,8509. Where are these letters?
1991.
The letters also stated that the performance security of the applicant would be forfeited. And after considering no, before that, you right? Huh? Before 8/11/2024, right? The petitioner was thereafter served notices dated 26/6/2024, 37/2024, and 3/10/2024. Is it correct? With respect to the loss for assignment of pretext. Wherein it was whether the applicant was informed that the corporation intended to blacklist the petitioner from future participation in any activity of the corporation. The applicant was also informed that the that the academic that the loss of the textbook was a serious violation which had put the academic life of thousands of students in jeopardy. It has caused financial loss to the corporation and also reflected the poor managerial capacity of the petitioner of the applicant in failing to keep a constant track of each and every consignment on the move and lack of instant response to the situation. The applicant had also submitted a reply to the notices issued by the corporation. By various letters, one of them being 25/9/2024, wherein it was stated that the investigation with regard to the loss of non-delivery of assignment was still going on. So the applicant further requested the corporation to release the funds for the work done by the corporate, for work done by the applicant. And if required, some amount of the money could be blocked till recovery of the loss of assignment. Yes, sir. Subsequent to the above, the petitioner was issued the two impugned letters dated 8/11/2024. Whereas the performance security of the applicant was forfeited and the petitioner and the applicant was blacklisted from participating in any forthcoming tenders for carriage of free textbooks on behalf of the respondent. Yes, sir. The petitioner's counsel submit that the blacklisting of the petition may be stayed so as to enable the petitioner to participate in the notice for inviting e-tender dated 21/11/2024 for carriage of free textbook for class K Shreni to class 12 for the academic section 2025-26 published on 28/11/2020. Learned senior counsel for the applicant submit that in terms of the judgment of the Supreme Court in the case of Dash versus Dash 2014 14 FC 721, comma, the blacklisting of the petition should be decided not only on the touchstone of principles of natural justice, comma, but also on the doctrine of proportionality. It happens that in the present case, the loss of assignment of the free textbook has been on account of the illegal action of the driver of the truck over which the petitioner had no put. As such, keeping in view the above fact, the involvement of the petitioner would have to be decided on the basis of his involvement, on the basis of his actual involvement in the loss of the fish. He also submits that the petitioner is not allowed to participate in the tender process. And if if the petition is later allowed, the same would cause injustice to the petitioner. as that with the amount to civil. Next up. With the, KP Pathak, clearance counsel for the respondent. On the other hand, submits that. But huh? Okay, submits that if the interim prayer is allowed by the court, that the stable amount granting the petition final release by way of an interim. He also submits that the issues raised by the petitioner are to be adjudicated after giving an opportunity to the respondents to file their affidavit. That's all. He further submits that the petition that the respondents are not willing to work with the petitioner because of the loss of two consignment of three textbooks, which was the responsibility of the petition. That's all. So further, the commercial interest of the petitioner cannot outweigh the public interest, which lies in the textbook reaching the hands of the student. Auto reserved. Are you right? Auto reserved. And in the main, we'll file affidavit. In the main, you write, heard Mr. Chaudhary and Mr. Sir, Mr. KP Pathak has submitted that he will file affidavit. I say, issue notice, sir. Issue notice returnable in 3 weeks. Mr. KP Pathak accepts notice on behalf of all the respondents and submits that he will file affidavit within 3 weeks. This is the matter.
Cannot date be given, madam?
Yeah. Affidavit.
Cannot date be. So
Oh,
nowadays I keep happening.
After Bihu,
22nd.
this again. This is the matter.
Right.
That's it. I have no respect. So the transactor, you go and take the permit. You go and take, this is not a post office. High Court is not a post office. Yes. So once he has given.
Informed at all here.
Huh?
You are not informed.
So now we'll record his submission and then you go and take it. What?
Did expire it.
So let him file again. He has not been informed. Let him, you see, if you can give him earlier, you give him a fact. He did not know. This is valid until 12 December. This is true. What is the LB Bathari wine bar? That is your thing. Correct. Heard, Mr. Huh?
Yes,
Before that, you write. Mr. Yes, your name is? Your name is not here.
Out of it. It- 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 But you're not
Okay, Mr. What is your name? A. Chowdhury. Appears on behalf of Mr. P. Pathak, learned counsel for the petition. Mr. R. Gogoi appears for the Excise Department. Anybody else? No one. Mr. G. Bokalian appears for this point number 4. While Ms. R.M. Deka appears for this point number 2. The petitioner's case is that the petitioner is the proprietor of MS LB Bathari Wine Bar, holding a valid license for retail vending of Indian-made foreign liquor for public consumption at Umrang So, Dima Assam, Assam. The petitioner's grievance is that he needs to transport liquor under Form 27 from the bonded warehouse to the petitioner's wine bar. However, the form number 27, which has been submitted by the petitioner to the Excise Department, has not been approved till date. Mr. R. Gogoi, Senate Counsel for the Excise Department, submits that he has received instructions to the effect that the petitioner's request to transfer liquor under Form 27 had been approved by the competent authority on 6/12/2024, and the same was valid up to 12/12/2024. Next up, Mr. A. Chowdhury, Sir, counsel for the petitioner, submits that the petitioner was not made aware of the fact that his Form 27 had been approved for a period of 6 days, 7 days. On considering the fact that the petitioner's Form 27 had been approved by the Excise Authority for transportation of liquor from the bonded warehouse to the petitioner's wine bar, and that the same had expired due to non-utilization of the same. This court is of the view that the petitioner should submit a fresh Form 27 to the Excise Authority. The non-communication of the approval of the petitioner's Form 27 not being attributable to the petitioner, the petitioner should submit his Form 27 to whom? Huh? To the point number 4. To the point number 4. 3. To the point number 3. To the point number 2. The approval, the once the Form 27 is approved, the respondent authorities can ensure that there is at least 5 days time for the petitioner to 5 days time to transport the liquor from the bonded warehouse to the petitioner's wine bar. Whatever, I said, no, don't say that. No, just read the last sentence. The responsible authorities shall ensure that the approval of the Form 27 is made known to the petitioner at least 6 days before the validity of the Form 27 expires. The writ petitions accordingly disposed of.
Yeah.
Every condition for certificate of ship after PL as well as the parts of shipping. That is the participated generally. Is the technically the highest bidder hearing is not qualified. It's
Right?
because he has no voting certificate of obtained ballot fraudulent. I have enclosed the copy ballot obtained to RTI. The authorities themselves are, but with regard
Page.
at page number 30 is the wonderful record. Finds the topic of at page 28. Right. This is the article from and the bottom information furnished as per information available to the top as discussion of what is this is Gopalson started about of account four times 7,900. So
8 lakhs.
it is 4 lakhs. One of the
Okay. Yes.
admittedly, and I give info.
So you have got to obtain the instruction. So Acha, he has not been settled.
Not yet. Assessment order.
So let them decide this issue.
My lord, I have also given representation to the deputy commissioner. He has not considered it as it and information is, my lord, they are going to set it in a payout. Therefore, I rushed. That department,
No, you see, I am not on this. I am only on the issue of whether he is going the defaulter or not.
admittedly,
Correct. So you see, madam, I think you have come slightly premature.
my lord, now,
You see, let them take a decision first.
my lord, order. Come in, sir.
No, then you can challenge. You can say that you see the ground that are taken now can be taken later.
My lord,
Let them take, see, Miss Madam, let them take a decision. Whether he's a defaulter, not a defaulter, who are you
my lord, let,
who are you to?
then my representation may be disposed of. And the constitution may give a direction. He is the default and admittedly they are default.
So it's a premature repetition action.
But I wait for my lord and order, then I am out. I'm the second
So
highest
what?
bidder.
Then you can come and say that this settlement is illegal.
Let them decide this representation then, like, at page 25. My representation is pending before the deputy commissioner. my lord.
Yeah. Coming too fast. too much in a hurry.
Madam, reasons for apprehension is that, madam, court.
Madam, everyone has apprehension.
represent-
Let them take a decision first.
Let-
If we, you see, everyone has a apprehension. All the writ petitions here, they come after the action has been taken. Now, if all the writ petitioners here had the same idea as you, that apprehending that they will do something illegal, if everyone comes, then we will never be able to do any real work. We'll be just working on the apprehension, speculation, and what might be, what might not be. That is,
Yes, madam, I have pointed out some.
madam, out here, how do you know that they do not know this issue? Why do you assume that they do not know that he's a defaulter?
Why not let the committee
You see, you are apprehending something, and you are saying that they don't know. I know everything. They don't know anything. Let us see. That is what you're saying. That is what you're saying.
Only I'm saying that the deputy commissioner has get this benefit. And why not, if there is settled that I'm out, because I have a problem.
Sorry, madam. There's so many cases. So many cases where settlement has been done.
And
And then when we find that it is wrongly done, it is wrongly done. If someone has been wrongly promoted, then wrongly promoted. If someone has been wrongly given some advantage, then wrongly given. But that's when they come, not prior to an action. Your right only flows when your right has been violated. As on today, nothing of yours has been violated. You are only apprehending that it will be violated.
just my,
So where is your case? Supreme Court has said that unless you can show that your enforceable right has been violated, then only you can come. Where is the enforceable right? None. As on date, you're not an agreed person. No cause of action.
Representation, then, but
Let me decide that matter. How many times will you say it? Correct. No, not representation. Yes, not nothing.
representation admitted factor, there it can be.
Heard. Miss Veda,
Teacher.
learned counsel for defense. Huh? Let me see the Vakalatnama. Have you signed the Vakalatnama? Name is there. Why is it not here? Third Miss P. Chakrabarti, learned counsel for the petitioner, who submits that the petitioner is a bidder for settlement of the number 79 Chatla Bill Fishery under Paul Garcia Revenue Search pursuant to a tender notice dated 7/10/2020. The bids were opened on 29/10/2020. And it was found that 3 persons had participated in the tender process, while the petitioner was H2, comma, the respondent number 6 was H1. The petitioner's counsel submit that the respondent number 6 is a defaulter in respect of another fishery, comma, namely number 20/42/44/54/69, Volai Suti Group Fishery, for an amount of rupees 4,07,9. Next para, the petitioner's counsel submit that in respect of the present tender notice dated 7/10/2024, the respondent number 6 had submitted a false Pakijai clearance certificate. Correct?
Right.
The petitioner apprehends that the respondent number 6 would be settled. Apprehends that the fishery would be settled with the respondent number 6. Despite the respondent number 6 being a default. Yes. So you inform your thing. Let it be decided. This is already come. The next step. Mr. P. Sharma, Learned Counsel for the Fishery Department, and Mr. M. Chetia for the chair for submit that the that the petitioner's case is based only on apprehensions and speculation. They submit that the present case is a premature case. I have heard the counsel for them. As correctly stated by counsel for the respondent, the present petition is premature case as the petitioner apprehends that the respondent number 6 would be settled with the fishery despite being a default. Though this court is of the view that the petitioner has got no locus standa at this juncture to file the present petition. Now, this court is of the view that the submissions made by the petitioner's counsel should be considered by the tender evaluation committee, keeping in view the letter number BRF -1 -2016 -352 dated 30/08/2024, issued by the Additional District Commissioner Fishery Market, which states that the respondent number 6 is a default. Consequent, this writ petition is disposed of with a direction to which respondent? With a direction to the respondent number 6 to consider as to whether the respondent number 6 is a defaulter, as has been alleged by the petitioner in this case. Prior to finalizing the tender, so the same is subject to the condition that the tender is not finalized prior to receiving a copy of this order and a copy of the writ petition, which is to be furnished to the respondent number 3 by the petitioner. That's all.
Motion kindly record that. Yes, that is order. Well, again, that will create the 2-3 days time will be,
I cannot spoon feed everything.
well, this
The writ petition is accordingly disposed of.
similar order,
Because
41 of the same,
whatever.
only the name of the part. I name of
It is different. And but letter number also different.
different.
Outer fisheries 49, 50, 51, 52, Mara Group Fishery. And the Bolgasia Group Fishery Revenue Sir. Pursuant to tender notice same. Tender notice dated 5/10/24. Then 3 people participated. Out here your H2 again. And the foreign number is H1. Then where is the additional disease letter?
Page
30. This is assistant commission. One thing you write,
27.
the decision to be taken by the respondent number 3 should be made after giving an opportunity of hearing to the respondent number 6. Then in this one, where is it? Page
Page
27. The letter dated, letter number, where is the original?
Page 29.
Can't we read the number? This appears to be all made up document.
No,
Well, give it to me. Let me see. Huh? I know. But what to do? Anyway, this also, how come it's like this? This is not the original. What does it say? Number BRF? What is it? Huh? BAR? Just give it to them. I cannot read. This memo number of BIR. What is the letter number? Where is the original? Where is it? Where is the original? It's made from some other document. Huh? Appears? Huh? Then you bring the original. I'm not passing on the order. I cannot read. This is the matter after the vacation. As the document relied upon by the petitioner at page 29 is unreadable. As the letter number at page 29 is unreadable. After the vacation.
Please, your lordship, my lord, the impugn order is at page 24, my lord.
Yes.
My lord, this order has been passed in protest with regard to the earlier minute taken in the meeting in the office of the deputy commissioner at page 15 annexure 1. By this order, my lord, page 25 order, my lord, by this order, one private market has been permitted to operate on Thursday. And now, if your lordship comes to page annexure 1, page 17, my lord, there was a decision earlier, my lord, when there was conflict of dates to run the market. In page 17, your lordship will find that the Sotaimari weekly Posu has be permitted to operate on Thursday. And the Gaurnagar weekly Posu has be permitted to operate on Tuesday. Now, my lord,
He operated on Tuesday. Yes.
in total disregard to these minutes, my lord, now this order has been passed to operate the Gaurnagar weekly Posu on Thursday. On the same day.
And you? You also Thursday, you also allowed Thursday.
Yes,
So both Thursdays.
yes, my lord.
So how does it matter? This is the authority. He has got the authority to.
No, my lord. That the Society Weekly Posuhat is a government market, my lord, and the Bornagar Weekly Posuhat is a private market, and there is a finding. Your lordship will find that page 18, my lord, and extra 2 that Bornagar Posuhat doesn't pay any tax to the government also, my lord. So since there was a conflict, there was a decision earlier to operate on 2 separate days. So in
Where is it to operate on two separate?
page 17, my lord. In 2000.
So it is done by the same officer, by the same authority.
Yes, my lord.
Then what is wrong? What is wrong? I don't understand what is wrong.
Yes,
Huh?
my lord.
2014 decision. Now they've changed their decision.
And secondly, my lord.
Where is it in the rule or in the act which says that a government market and a private market cannot open on the same day?
No, there is no such rule.
Then?
But since there was a conflict, my lord, therefore there was a earlier decision, my lord. And if your lordship peruses the whole order at page 24, it says that it has been passed in pursuance of a order passed by this honorable court, my lord. Whereas that order doesn't say of fixing any particular date like this, my lord.
So?
That order, page 24, if your lordship. Whereas as per directives contained in the order dated 21/8/2024 passed by the Honorable Guwahati High Court, this order. And this order, your lordship, at Annexure 3, my lord. Annexure 3, page 22-23, my lord. In this order, nowhere there was a direction to fix the date as Thursday for this month.
So how does it matter if
It matters, my lord, because because of the running of the private market.
I don't know. You tell me. I don't. Is there any?
System or obtain notice or instruction at this moment. Why this has been done in total disregard to the.
No. First, you tell me
Yes, madam.
why it cannot be done.
It cannot be done because if 2 markets are run on
So
the
what?
same day and
Why not?
adjacent place, obviously.
Whole of what is running every day. So what is some market should run on some days, some markets on some days or what? Why should it be any different in the villages?
My lord, why they cannot run as per the earlier decision on Tuesday or Friday, my lord?
Okay, I don't find any. You tell me what is the? You know the lessee by the market. Who are you?
Primary Bazar Unnayan Committee, who is looking after the development and maintenance of this market, my lord.
Which market?
This primary Bazar.
The government market.
The government market, my lord.
Huh?
Yes, my lord.
No.
Yes, my lord, government market. That is.
Huh? They cannot. It is the Anchalik Panchayat. You have to. The government is looking after his market. He has got no local
They are not
standard.
running, my lord. I am not saying they are running, my lord. They are not running.
So
the
what?
market.
So what is your local standard to find?
My lord, what that is a registered society, my lord. Yes, my lord.
So you have been allowed. You have been allowed to run the market.
They get a nominal fund from the earning of the market to look after the hygiene, the maintenance.
Show me where. Who has given you the power?
But that is, my lord,
Sorry.
this. Oh, my lord, we have filed a representation at page 5, annexure 5.
I don't find any case. Sorry.
My lord, that representation may be directed.
No. I think I will discuss it. No case. Right. Right, Mr. DP Bot. Senate Council for the petition. To submit that the order dated 28/10/2024 issued by the District Commissioner Golpara, by which the Gornagar Bridge in Yali Pashu Hut bracket, a private market has been permitted to operate on Thursday. Repeat second. The additional charges subject that in terms of the meeting minutes dated 27/5/2014. Held in the office of the DC's office, Golpara, to sort out the anomalies of the Chatai Mari Pashu Hut bracket government market and Gurnagar Damri Bhasha Bridge nearly Pashu Hut. It was decided that the Chalai Mari weekly Pashu Hut would be permitted to operate on Thursday instead of Friday, and the Gurnagar weekly Pashu Hut would be permitted to operate on Tuesday instead of Friday. The petitioner counsel submit that the date when the markets would be open in terms of the meeting minutes held on 27/5/2014 has been changed by the impugned order dated 28/10/2024. Wherein the Gurnagar Damri Bhasha Bridge Kenyali Pashuat has been permitted to operate on Thursday morning. Next one. The petitioner's counsel submit that the district commissioner does not have, could not have changed the date of operating the private market on the same date that the government market was operating. It's on different land, no, it's different. Yeah, next one. Next one, Mr. E. Bokalian appearing for 2, 4, and 5, and Mr. S. Data appearing for 1, 3, and 6. Submit that the petitioner has no local standby to file the present date petition, inasmuch as he has got no role to play in the operation of either of the markets, that is the government market or the private. Next one, Mr. S. Data appearing for the PNRD department submit that the government markets are all being run by the concerned Anchalik Panchayat, and the petitioner is not running the 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 the, the Kalamairi weekly Pasha Pashuhat at present. Next, I have heard the learned counsel for the. It is not in, it is an admitted fact that the Chalamari weekly Pashuhat bracket government market and the Gurnagar weekly Pashuhat bracket private market are being run on are being run in different locations and on different lands. It is also an admitted fact that the petition, as on date, is not having any role to play in the running of the the running of either of the two markets. As such, this court is unable to understand the reason for the petitioner making a challenge to the date when they're making a challenge to the district commissioner's decision to allow the private market to operate on Thursday. In the case of Ayub Khan Pathan versus the before the death versus the victim. In the present case, no enforceable right, no legal or fundamental right of the petitioner has been violated. And as such, the petitioner cannot be said to be an aggrieved person. So as to pray for a writ of certiorari under Article 226 of the Constitution. Next, sir. The above being said, when the earlier date of opening the market has been made by the district deputy commissioner, district commissioner Golpara, and the said date had been changed by the same authority in the year 2024. This court is unable to understand as to how the district commissioner cannot review its own decision. The petitioner has also not been able to show any law, rule, or guideline which prohibit the operation of the government market and a private market on the same day of the week. These are the reasons stated above. This court finds that there is no merit in the petition. The repetitions are currently this. Right. A Sharma, learn counsel for the applicant. Submit that in para 3, para 3 is there. Please submit the person sensor to be filled respondents number 20. The press allowed. Sensor respond number 20. Applicant to submit a corrected copy of the first title to the registry within 3 days. I is accordingly allowed and disposed of. Then in the same order, just a minute. In the main case, you write in view of the order dated today is 17th, 2024, past is ISC number 3878 of 2024. So are if the respondents number 2 and 6. If you notice to the respondents number 2 and 6, petitioner takes steps for service of notice upon the respondents number 2 and 3 within 3 days. List the matter. Suppose. Same. Exactly same. Right. How much? 1 lakh. So both of them have gone down by 1 lakh. When are you going to make the full payment, madam? We keep on doing this. Okay, by January end, you give 2 lakh. 2 lakh each. Only. Okay. At least you're getting something. Mr. N. Gogoi appeals for the petitioner. Miss petitioners. Miss DJ submits. Petitioners or petitioner? Petitioner. Miss DJ, Senate Counsel for the AFTC submits that rupees 1 lakh each has been paid to Mr. Ratan Chandra Boro and Manin Boro on 11/12/2024. So as such, the amount payable to Ratan Chandra Boro and Manin Boro is 10,59,996 and 344,897. Full stop. This is the matter on. No, too far. This is the matter on. No, this is the matter on 21. 20, okay, 22. 22, 1, 24, 25, by which date? It is expected that at least 2 lakhs each should be paid to the petition. Payment of money whole. I have to pay the. Have you paid? Whole. Then when are you paid? What may I pay that? It is admitted. It is the admission stage. Now you have got to pay. All amount. How much? I think 5 to 6. 5 to 6 lakhs. So if it's small amount, in pocket change, you give it that. What if it is not supposed to get some payment? It's the BSNL is involved. So some payment is to be received from the BSNL. And the amount is not receiving. Therefore, they are not. BSNL has no money. BSNL to no business also. No one is buying BSNL SIM cards also. We supplied labor to the BSNL, and that amount was not paid for which we are going to pay the penalty. For not paying the amount of the BSNL. We are having a case with BSNL. I think I make them a party. That is it. What to do? No, how much will you pay within 1 month? Within 1 month, how much will you pay? You have to pay, otherwise we'll pass orders now. It's going to be financial year, we're going to pass. How much is the liability about outstanding dues? 5 to 6 lakhs. Total it was 13 lakhs. They have paid. They are making payment. When was the last payment you made? Okay, Mr. Ash Sharma appearing for the petitioner submits that he will produce documents to show the last payment made by the petitioner to the respondent number 2 to 5. He also submits that he will obtain instructions as to the exact amount still payable by the petitioner to the respondent. On the other hand, the On the other hand, Mr. P.K. Roy, then counsel for the point number 2 to 5 can also obtain instructions with regard to the exact amount payable by the petitioner. This is the matter on given it. Okay. Be voter matter.
Web page or
When you go there,
appearing on government finger, Mr. K. It is not well.
doesn't matter.
Finally, matter may be taken.
Will dispose of. No need. This is here. Right. Mister, your name,
MU
MU? So you got it. Let counsel appearing for Mister,
MUE.
the counsel for the petitioner. K. Buyat.
Yep.
Let counsel for the petitioner. Also heard Mr. D. Sharma for respondents number 2 and 4 and G. Sharma and Mr. You got it? 7. The writ petition is agreed by the inclusion of his name in the category of D voter by the Election Commission of India. Full stop. Mr. D. Sharma, the counsel for Spencer, has submitted a letter, has submitted letter number BL-06/2022/18 dated 31/5/2022 issued by the election officer, Barpita, Office of the Deputy Commissioner, Barpita, Election Branch. Huh? And letter date and letter number BPTA/B/22/555/1091 dated 31/5/2022 issued by the Superintendent of Police (B) Barpita, addressed to the election officer Barpita, which states that the case of the petitioner is pending before the Foreigners Tribunal, Barpita, as FT case number 973/Roman 3/2017, comma, SP reference number 110/60, the Foreigners Tribunal 3, Foreigners Tribunal -3, yeah, Barpita. Next up. The letters dated 31/5/2022 and 31/5/2022 issued by the election officer Barpita, and the letter dated 31/5/2022 issued by the SP (B) Barpita are made a part of the report and marked as initial X and Y respectively. Next para. In view of the petitioner's case being referred to, in view of the petitioner's case, in view of the pendency of the petitioner's case before the Foreigners Tribunal -3 Barpita, the present writ petition has become infructuous. The writ petition is accordingly closed as infructuous. The petitioner should attend to the tribunal proceedings, to the proceedings before the learned tribunal, wherein his case is registered as FT case number 973/Roman 3 Act 2007. Writ petition is accordingly disposed of. And next year, yes. Infrastructure. Matter is infrastructure.
Lordship, my senior is actually out of station today.
It's infrastructure.
To be taken up little.
It's infrastructure. Period is over. 22 it was over. What remains?
Stand Lordship, but I'm not qualified to.
You're not qualified. You don't know. You haven't read the file.
Lordship, just the bare basic of it.
Hmm?
Just the bare minimum. I know just the bare fact that I would not be able to take the matter forward. My senior would be in the capacity to do it, but he's currently out of the kitchen.
Anyway, I'm closing it. Yes, I don't think, and it has been retendered, is it? For, he is interested in which one? All three? All three. If it's all three, then if one is still there. Okay. So all these are all, this mining lease had been given to him for 7 years, expired in 22. Right. Mr.
R. Bhuya, Lord.
R. Bhuya appears for the petitioner. Mr. R. Gogoi appears for the forest department. The issue pertains to but this pertains to Bakitai proceedings or what? Then this is not infrastructure there. So he's challenging that.
Yes, Lord. That
Okay, anyway, right. So whatever I said. The issue pertains to the Bakitai proceeding that has been initiated against the petition. Even though the mining lease, which was for a period of 7 years, had expired in the year 2020. On the prayer made on behalf of the petitioner's counsel, this is the matter after the Bihu vacation.
much okay.
24. Yes.
File an affidavit.
Is it a covered matter? Where is that the order? You don't know. It's a covered matter, Mr. Counsel. So many orders have been passed. Unfortunately, I thought you'd have. Six, three, six.
So, my lord, basic term after vacation, let me just go through that order.
No. We are allowing your writ petition. What are you talking about? Allowing it to the extent that you have not been given the minutes and that document. What is that document? 145? That executive committee resolution 6. This has to be given to it. And the confirmation. Both. That's all.
Without the confirmation of the state council method, or I could do the suspect.
Right, Mr.
Eda.
Eda, that is counsel for the petitioner. Also heard Mr. P. over done it counsel for the all the report. Then you take this para 1 and para 2, para 3, para 4, para 5, para 6, para 7, para 8, para 9, para 10. That's it. So basically what we have done is till the resolution 6 of the executive committee and the confirmation made by the state council is provided to the petitioner, the orders of the cancellation of the license of the petitioner shall remain suspended. The above is however subject to the condition that the petitioners approach the respondents with a certified copy of this order along with a copy of the writ petition within 7 days from today. 10 days. Okay, 10 days. I'll just read, it's para 9. How many petitioners are here? 12. Okay. Election? 134 to. So we set aside this. Right. No, that's what I've already said. Already said here. Yes, yes. The orders of cancellation of the licensing of the petition shall remain suspended. That's enough. Till receiving that. So I won't mention these dates because they're all different dates. One is on 5/5, one is 10/5. This is what? Well, because this vacation here certified copy. Vacation, like he said, vacation. No, you will get it. You will get it by tomorrow. It will upload it today. Itself. The registry is going to remain open for 3 days. Only thing is your holiday plans will have to be slightly modified. Your unlisted matter has not come. Maybe it's some defect.
No, madam. I have checked. No defect is there. But they said that they will send. Let it be tomorrow or day after.
Tomorrow.
Let it be day after.
Okay, 20 then. I won't be here.
20 is the last day, madam.
I know I've got to go. I've got some
I'll leave it to you.
personal problem, personal matter. I know. So whoever will decide. Whoever. 20 they want it. On the prayer of the parties, is the matter on 20.
Interim order.
Interim order.
Just there.
Interim order to continue till the next day.
23 PM.
Yes. To what effect? Only one thing I want to know. Was notice issued to him? What? In your parawise comments, you please read. What does it say that notice was issued to him? I think that's the only issue right now, for the time being. If notice is not issued, then we can dispose it off. If notice issued, then let him file. Let him file.
Yes, Madam, may I request document? Madam, I am a Alphagen supplier of the electrical function. And as a officer by this impure blacklisting, case. So my lord, I humbly pray that they may show the notice issued online, whether I have because participating constitution bench says, unless communicated to the concerned party, this is no order. So
Naturally, it has to be communicated.
yes. So in my, as per my instruction, my lord, this is affidavit. So I am my lord, please, what I consider.
That I don't know. That is something. That is a disputed question of fact. Okay, okay. Now you file affidavit and you bring the records on the next day. Right, Mr. M. Chetia, Learned Counsel for the respondent submits that Parawise comments have been received and he will be filing affidavit within 3 weeks. List the matter after 3 weeks. On the next date, Mr. M. Chetia shall produce the record, shall also produce the record to ascertain as to whether the notice that was issued to the petitioner informing him that there was a proposal to blacklist him has been actually furnished to the petitioner.
On 20th, I have some related. Let it be on 19th. You have to pay.
19th, I have a problem.
Then after we
Tomorrow?
he is not good. I'm ready, but he said that he's not.
No, he said today he's not ready.
No,
Tomorrow, sir. Okay, then you tell him, okay, list the matter after the, give a date in the January. Money paid?
Okay.
Money has been paid or not? Huh? What does it say? Okay. Okay, right. Mr. B. Gogoi, Learned Counsel for the PWD submit that the proposal for payment of the petitioner's contractual dues is under process and the delay has been caused due to the discrepancy in the name of the petitioner, which is Shri Bichuram Chauhan, while the finance stamp portal shows the same to be Shri Bichuhu Ram Chauhan, BICHUHURAMCHOUHAN. Okay. The other one will be Bichuram Chauhan will be here in the petitioner. Accordingly, list this matter after the vacation.
Can a date be fixed?
Brief after we have. Item 30. Yes.
Just my lord,
I kindly consider the order passed by the Lodgima Court.
In view of the above, service is complete for point number 4.
Rest. And 11,
No? 4.
dot mechanic. Dot mechanic 17/9/2024. 17/9. It says in view of the above, it may be said that the service in respect of the respondent number 5 to 10 has been completed.
Okay, 5 to 10, all right.
5 to 10.
What
And
about
we
11?
directed to take steps on respondent number 11 by the stick. We did, my.
Huh?
We served, my lord. That is, affidavit is also part of it.
But Lawazima code doesn't say that. Lawazima code says that service complete for point number 4, not 11.
Not 11, 5 to 10.
Then why did you want to take me to this Lawazima court order?
I'm just trying to show service has been complete.
But it doesn't say so with respect to 11.
In respect, we are directed to take steps by the stick. We serve the stick and will file affidavit, part of the report.
Huh? I don't know. Lawazima court made a mistake. Everything is about 11 and at the last he put 4. That's what I was asking you.
Perhaps service has been completed. Maybe posted for hearing and admission hearing after under the immediately after.
Yeah. You're right. As per the affidavit of justice service filed by the petitioner, the point number 11 has been served notice. Accordingly, notice is deemed to be served upon the respondent of 11. Mr.
And now,
N. Nath, learned counsel for the petitioners, and Mr. N. Upadhyay, learned counsel for respondent 1 to 4. Submit that. Pleadings are complete. You're not
affidavit has
filing.
not been filed.
Are you filing or not filing? Okay, so then don't say Mr. M. Nath. You just say Mr. N. Upadhyay, counsel for the respondent number 1 to 4. Is granted 4 weeks time to file affidavit. In the position, list them out. Yes.
My lord, this is the second round. There is one review petition filed by the other side, and the writ petition has been filed by us. Now, on the earlier round of litigation, your lordship concluded that the rejection of my technical plea was argued. Now, this time, my lord, they have, the state government, though they have taken the plea earlier also. Now again, they have taken the plea that I was a subcontractor, I was not a prime. But my lord, state government, in their earlier affidavit, groundly, they have specifically taken the, whether it is permissible. And as far as the private respondent is concerned, we sought to be favored, my lord. They have criminal cases, they have been charged with it, they have withhold of. Their stand now is, there is no clause in the tender that they should disclose. In fact, there are clauses which require. That is in nutshell the area. How long are you going to take?
It takes some time. No, yeah. It's directly proportional to.
Not necessary.
Anyway, no, the thing is that if you can finish it, it's okay, but I don't think you all are going to finish. It'll take some time. And this week is all motion and we're very busy.
My lord, I was thinking of 9th.
We can try. 9th is
the Thursday.
no, I know. All your cases are urgent. What to do?
Because sixth, we are reopening. Sorry, third.
Third.
Effectively sixth.
Yes, effectively. See. Okay, right. On the prayer, the parties list the matter online. Your bid has been considered, but your bid was
So
considered.
subsequently, it has been rejected on the ground that I am a subcontractor, not a prime contractor. Despite your lordship, yeah.
Huh? On the same ground.
On the ground that I am a subcontractor. Though there were tenders and all.
So basically, whether he can be his experience as a subcontractor can be considered. No, only on this ground. Only on this ground. What is the law? Only on the ground as to because you see in some contract, say with say, even in with Oil India and all, the experience if say if for transportation of oil, the experience gained by putting your tankers with the bidders tankers can be considered to be experience.
Exactly.
Ah. Okay. So there is no judgment. No judgment.
Anyway, my lord, there are clauses which supports our case explicitly. Man. Please.
Find an affidavit.
Yes. Okay. Mr. HR does appearing for the 1 to 4. Submit that Tarawise comments have been received and they will be filing affidavit within. No, within 2 weeks. To stop. Accordingly, leave this matter after the vacation.
Till then the notification.
Huh?
Notification of vacation. Thank you notification.
No. Nothing will happen. Quite sure.
Much.
But in this case, Lord, in terms of the order dated 5/9/24, the mediation proceeding was completed.
Yes.
Now it is going on.
Okay.
So,
Is it taking very long your mediation?
no. Several sitting took place.
Okay.
19/9, 30/10, 3/10, 22/10, 4/11, 14/11, 19/11.
Ah. Okay. Ah.
the subject matter of the mediator.
Go beyond. I don't know. Let the senior counsel take a call. Let him tell his client.
So this mediation proceeding was initiated on the basis of this.
No,
He made
no,
a proposal.
maybe. But now they're taking a stand that mediation is not going anywhere. You see, that is his now.
It may call for a report from the mediator.
No, I will not call. You have to, you see, the thing is that you also have to take a decision as to whether the mediation is progressing or not. If it's not progressing,
My client came to my house, day after and day before yesterday. They are happy with the mediation. So that's the
and what you all can do is if you think that going nowhere and it should be referred back to court, then you'll file an application there. Tell the mediator this is the thing. Then you can submit it here. Also, this is what you have said that it should go back when nothing is happening.
Yes.
Because right now, on the basis of your submissions, without the proper instruction from your client or written instructions, it's very difficult for this court to pass or pass any order.
If you don't ask them for other thing, very well.
Let him do it.
No. Let him file an application that no mediation is required. If that,
Right. Mr. A. Das Gupta, there is senior counsel for the
my
petitioner.
view is
Submits that, huh?
my view is that mediation should continue for some time because it's a long pending matter. And my client also told me that there is a lot of progress. At that juncture, if you call it, then it will be
But you cannot
all
try
right.
to,
Should may fix the date.
you cannot try to, rake up the entire controversy from the start. You'll have to confine your issues to the
No, it is
present
this
day.
submission. I don't know what had happened.
Okay, anyway.
Hmm.
Right,
I
Mr.
don't
A.
know
Das
what
Gupta, learn counsel for the petitioner. Submits that the matter is undergoing mediation. On the other hand, Mr. S. Sharma, R. Sharma, learned counsel for the respondent, submits that no progress is being made in the mediation proceeding.
No, the progress has been made.
He says no progress is being made.
His offer has been
Comma, in as much as the offer of the management is not being accepted by the writ petitioner, by the writ petitioner.
what their offer.
The counsel for the party shall obtain further instructions with regard to whether the mediation proceedings are going to have any effect on it.
May I request my friend to give their offer? About their offer. Yes, submit my.
You give, I'm also, you give, release the matter after 4 weeks. Item. Okay, 31, 32, this is in order to proceed. This is an.